hearings after the press conference on the 27th of November, which was the plea reading by both defendants, Fatia and Haris. We have the 4th December as well as the 11th December, the reply and rejoinder reading agenda. And today we are now welcoming 4 speakers who will share their expertise and perspectives on the ongoing case and hearing until the next year. Therefore, I would love to introduce to all the speakers, to 4 of our speakers here. We have first Muhammad Isnur. He is the chairperson of the Indonesian Legal Aid Foundation, as well as one of the law advisors for Fatia and Haris. Second, we have Norman Voss, the secretary coordinator of the Human Rights Monitor in Germany. Next, we have also Cornelius Hanung, the East Asia and ASEAN program manager of Forum Asia. And last, we have Justin Lavarde, the program officer at the Human Rights Defenders Desk from FIDH. I welcome to all of our speakers. Next, I think we can just head on to the first speaker. So I would like to give the floor to Norman. Thank you very, very, very much, Norman. How are you? That's the first thing I'm gonna ask, actually. How are you, Norman?
Hi, Nadine. I'm very good. Thank you.
Oh,
thanks for inviting me.
Oh, that's great. Okay. Yeah, of course. It was a great pleasure to have you in this discussion, and we would love to hear more of your presentation, since we know that the Human Rights Monitor, maybe you can also introduce Human Rights Monitor after this, have been focusing on monitoring Papua's ongoing violence cases. And I think this is a very remarkable work. So yeah, can you please tell me more about Human Rights Monitor and also the current condition of Papua itself and the ongoing violation cases, as well as leading on to our discussion on how Fatia and Haris's fatal role to unfold and also unpack the truth in the cases. So Norman, if you may.
Sure. Thanks, Nadine. Hello, everyone. Yeah, my name is Norman Voss, and I'm a coordinator in the Human Rights Monitor project. That's a project based in Europe. I'm sitting in Germany, and we have been monitoring the human rights situation in West Papua for the last 2 years, and together with other networks for longer years than that, and are trying to establish a verified picture of the situation of human rights violation trends, dynamics of the conflict. And for this reason, we are documenting some dozens of cases every year. And when I look at the numbers that we have there, for example, of last year compared to this year, we can look at the number of extrajudicial killings. In 2022, in West Papua, there were some 15 cases that were recorded where civilians were killed unlawfully by armed security forces, meaning police or military or joint forces. In this year, until the end of September, so in the first 9 months, there have been 39 such cases recorded. So there's a strong increase that is very worrying. We can see a similar increase in the number of interactions of armed groups, such as the TPNPB, that is often in armed clashes, combat situations with the Indonesian military, TNI. And we see an increase in that trend as well. But it's important to distinguish the two areas that both cause suffering. But looking at the human rights aspect, where civilians are concerned and victims are not members of armed groups, we can see a worrying trend. But more or less for the last 5 to 10 years, the number of killings have been in the order of 10, 20, 30, which makes it one of the highest in the region and is making up practically the largest part of the number of cases of killings in Indonesia. So West Papua remains the most serious human rights conflict zone. in the country, and I would say in Asia, one of the most serious ones. We also record cases of arbitrary arrests of demonstrators or people who express their political opinion in a peaceful way. And the number of cases here amount to hundreds per year. So these are just some examples. Cases of torture are very rampant and happen frequently, and we can see that the victims of all these violations in the Papuan provinces are by 99% indigenous Papuans, who make up a small share of the population. The Indonesian government has stopped publishing disaggregated data on the population for some years, despite recommendations by UN mechanisms to provide this information. But we can estimate that the number of indigenous Papuans is something like 30% or even less, as compared to some 90% a few decades back. I assume that generally viewers are familiar with the situation of human rights and conflict in West Papua. So I'm not going so much into the history, but the conflict itself continues to be unresolved and was aggravated a lot when the provinces, the Papuan provinces, were split up further last year, and this split up happened without consultation of the Papuan constituencies that were supposed to agree to this. The autonomy law itself has been cut down in many regards. So when people bring up the argument that West Papua has an autonomy status, I would say by law it had an autonomy status, but that was not fully implemented. So in practice, it did not have an autonomy status. And by law, it now has even less of such a status. This has aggravated the situation, and as I described before, the number of cases of violence against indigenous civilians are considerably high. So the question for many Papuans that arises is what can provide security for them? What can protect them from this violence? Supposedly, institutions of justice such as the police, the courts, the prosecutors should handle that. Komnas HAM could play a strong role, but in reality, this is not the case in Papua. I would say the level of rule of law in West Papua is the lowest all over the Indonesian territory. So there's much less you can expect in terms of protection from a legal system in West Papua as compared to living in Jakarta or living in some other provinces. In this context, it is, in my view, understandable that many Papuans, especially those living in highland regions that are strongly affected by conflict, seek for protection. We have seen a lot of IDPs. People leave villages after they have been bombed and attacked by the Indonesian military or police or joint security forces. The TPNPB, a guerrilla army that promotes, that aims to achieve political aims through military actions, and is in the context of Indonesian law considered as an illegal armed group, in the context of the view of many Papuans as a kind of liberation army. But what we see is that hostilities between the TPNPB and the Indonesian military have often occurred close to civilian settlements. In some cases, TPNPB are members of village communities and are the only people who, in the view of the villagers, protect them from violence of state security forces. In other cases, these villagers suffer themselves from the fact that TPNPB and the Indonesian army repeatedly have clashes, and they just want to have a peaceful life in their village, continue with growing crops in the garden, keeping livestock, and running a sustainable life. But when these villagers are expelled, displaced by military actions, mostly from the Indonesian government side. They live in the forest, they live in IDP shelters, IDP, internally displaced persons. They live in shelters, they live in the forest where they have much less access to healthcare and nutrition. As a result, the mortality rate of these civilian populations, indigenous civilian populations, is, while being in these IDP locations, much higher than it is in their home place. We have documented one such locations in detail in 2021 in Kivirok, Pegunungan Bintang Regency. There has been a military operation that resulted in some more than 2,000 members of the Ngalum tribe, Ngalum Suku, to be displaced. When some of them tried to return back to their villages, snipers of the Indonesian armies were shooting at them, resulting in the killing of one. So it was practically the Indonesian security forces prevented them from returning to their home and caused for them a condition that led to an increase of the mortality rate and is effectively a displacement that was conducted not randomly, but as a systematic approach of an operation by the Indonesian military. Now, when we look at operations that are systematically and displace people or cause conditions of life that result in the death of them or a part of them, then this can amount to crimes against humanity. You can find research available in that direction on our website at humanrightsmonitor.org. In this research about this particular incident in Kivirok, we see these conditions as largely met and expect actors like Komnas HAM to start investigations. Now, this is only one example. The full number of IDPs, the picture of IDPs, internally displaced persons in West Papua, is much higher. In the Nduga Regency, we have almost 57,000 since 2018, 57,000 indigenous people displaced. More than 600 of them have died since then, so the number is reduced. From Puncak Regency, there are 2,724 that we have recorded. From Intan Jaya, since 2021, there are 5,859. From the Maibrat Regency, 5,300. In the Pegunungan Bintang Highland Regency, Kivirok District, 2,252, as I mentioned. 74 of them died by now. There were another 91 displaced in the same regency in Seram Bakon district earlier this year in September. In the Yahukimo district, Yahukimo Regency, we have some 2,000. Another 500 were added to that in August this year from the Dekai district. In the Fakfak Regency, we have another 500 from August this year. So the numbers were high in 2021 and in the second half of this year. The total number of IDPs are, according to our information, at least 76,000, which is considerable. Now, why are all these conflicts happening, resulting in so much suffering for the civilian population, also suffering for the non-indigenous civilian population, horizontal conflicts, violence, and there is a political conflict behind it that is unresolved, a political conflict to which the Indonesian government, to our information, has until today not been willing to sit down on one table with the Papuan representatives to resolve this permanently. So this conflict is going on, and as I explained, rule of law missing, being absent in Papua, while at the same time having this very overproportional high military presence results in a special political context. So politics without military is practically not possible in Papua. Politics and military interest security forces are heavily intertwined. One reason for this is the way the military is generating income from businesses, such as natural resource extraction businesses. Another reason is that since Indonesia does not really have external serious threats, the main, so to say, business of the military is to deal with internal conflict areas such as the one in Papua. So as long as there is a resistance in Papua, the military is receiving strong support. I'm aware that many actors in Jakarta, from different parties, from the government, have been trying to find a solution for this conflict and have been making many efforts. But so far, none of them have really resulted in a resolution to this conflict. That's why I really need to encourage all actors to push for this and push for openness. The military itself, I would argue, has their own interests in West Papua, and some of the politicians do. And this that was done by a coalition of Indonesian civil society organizations, and that then Fatia and Haris have presented in their video. A very important research that shows the link between some of these businesses and Indonesian politicians. This is research so difficult to do that practically actors in West Papua would be under a threat of killing, under a threat of life if they would go ahead with this. But thanks to a very strong civil society group in Jakarta, this research was published and can really contribute to putting light on the dynamics behind this conflict that keep this conflict going. So putting light on this and promoting in that direction security, peace, and human rights in Papua was then faced with a prosecution under the ITU law with the demand of sentences of 4 years, 5 years that has not been demanded under this law ever before. So this is a very aggressive, hostile act, in my understanding, of the prosecution against human rights defenders in Indonesia that have done research, very well-funded research, and raise these very valid point in the interest of promotion of human rights and peace in Indonesia. And therefore, it is a disastrous result that for making this contribution, the two have now been charged. Yeah, thank you.
Thank you very much, Norman. And I agreed on your how you emphasize that not only did Fatia and Haris unravel several key actors who are clearly involved in this over deployed military activities, but also what has been going on inside Papua, and this did not really do justice. Because although both Fateh and Haris have articulated what has been researched by a lot of international actors, such as also the Human Rights Monitor, but what they articulate and what they depict in the YouTube channel actually resulted to their criminalization case. And by that, we can now hear more from one of Fatia and Haris's lawyers, Muhammad Isnur. Hello, Mas Isnur. Thank you so much for joining. We know that you have a packed schedule and you still have the energy and time to participate. Thank you so much. Maybe Mas Isnur, I would like to ask first, how are you? That's the first one.
Yeah, thank you, Nadine, Justin, and Norman. Good to see you. Yeah, actually, I'm health and well, but my wife no on sick, and yeah, I have to handle my son and daughter. But no problem. Yeah, I will soon to discuss about this tonight.
Yeah. Thank you. Thank you so much again, Mas Isnur, for joining and to have your juggling activities. Maybe just to now jump in to the discussion part for Mas Isnur. I would
Okay.
like to hear more of your perspective because you have been attending the whole processes of the hearing starting from the 3rd April, which was the first hearing up until this moment. So please give us maybe an updates on the main oddities for both Fatia and Harris's case before and also during the hearing process.
Okay, Nadine, I will try to presenting some sort memory during the hearing in the court. I will use my PowerPoint presentation. I'll try. Is it work? Is it work,
It
Nadine?
works.
Okay. Yeah, so how it started, yeah, as already we know, a YouTube podcast published in August 2021, between Haris and Fatia. It's Haris Azhar YouTube, Ngehamtam. So Haris Azhar usually invite a lot of activists to discuss about human rights. And actually, Haris Azhar mentioned a lot of government official, not only Luhut, yeah. And in the discussion, discuss the research report of 9 civil society, ya, Presiden Indonesia, YLPHI, Walhi Pusaka, Walhi Papua, LBH Papua, Kontras, Mining Advocacy Network, Chatham, ya, Greenpeace, and also Trend Asia. The research focus on Intan Jaya area. So uh, there are we found, yeah, the economically and politically linked to mining business involving retired generals, including Luhut, and also lots other generals and government official. So it's relating also between the presidential election with the team in the election process. So seemingly tarnishing Luhut rightful image, since his name was mentioned involved in the podcast as a person involved in the business. So actually we are using Luhut and another government official as PEPs, yeah, politically exposed persons. So a lot of our regulation mandatory to publish and also to due diligence when one person with exposed personally like Luhut having a lot of corporation, yeah. So Fatia and Haris were sued by several laws, including ITA law, yes, number 27, yeah, paragraph T and article 45. It's very rubber article, we know. And the last situation, the government and parliament member, House of Representatives, agreed to renew the law, but still exists, yeah, still now knowledge the article. So they only changed the number of sentencings from 4 years to 2 years. So it's the article still will happen in the next year. So another article also charged with the number 40, 14 and 15, and also 30 3010, yeah, from the criminal code. So it's the legacy from colonialist era, yeah, like legacy from the Netherlands in the past, yeah. And the new criminal code has changed the article, but the article and the criminal code implement in 2016, 2026, yeah, sorry. A hearing update, Fatih and Haris have undergone 28 trials, and the public prosecutor also failed to present, yeah, expert and witnesses in the police investigation. Like in the police process, police use as a name Trubus, yeah. Trubus is a criminal expert who said yes, this case having a criminal measure, but the judge filed to present Trubus. Also, the prosecutor said there are riots, and there are witnesses to riot, 2%, pro cons and in YouTube comment. But in the hearing process, the prosecutor failed to present the witnesses. Sorry. And also the lawyers from Fatia and Harris presented highly recognized expert, as such as Yunus Hussein. Yunus Hussein is usually very often invited by prosecutor and also KPK to explain about the money laundering and another about public politically exposed person. Mas Ahmad Santosa, we already know as Ahmad Santosa as a former leader of KPK, and also he mentioned and as trainer, he is a trainer for thousands judges in the Supreme Court. But we already explained how Fatia and Haris as a public defender, as a human defender, as environmental defender. Also Herlambang Perdana Wirataraman, also Faisal Basri, Rocky Gerung, and others. But in the end, Haris Azhar was charged by the prosecutor in maybe 3 weeks ago with 4 years imprisonment. It is the maximum number in the ITA law. So the prosecutor used the maximum imprisonment, charged with the 4 years, and also a fine of 1 million rupiah or 6 month imprisonment. So it's the choose when maybe Haris giving 1 million, not add the 6 month imprisonment. And also we already knew prosecutor just removal YouTube discussion that discuss Luhut alleged involvement in mining in Papua. So it's the aim. Prosecutor want to remove it, to delete the YouTube. So it's relating very relate with the freedom of expression and assembly. And also for Fatia, meanwhile, charged with the 3 years and 6 months in imprisonment, and also a fine of 500,000 rupiah or 3 month imprisonment. So the lawyers, me and also the team of advocacy for democracy submitted of 560-page defense. Is very lot of paper, and we read the defense, the pleadoy, since 10 p.m. 10 a.m. until 9 until 10 p.m. So it's 12 hours we read the pleadoy 3 weeks ago. And not all we read, but it's we have to read because the jaksa is corrupt. A lot of mention, lot of opinions from the witness and experts. So we also attach more than 20,000 to 2,700 page of verbatim. So the black paper of the trial. So we giving the judge and also the prosecutor the real verbatim of the from the hearing. And also we giving the people, we giving the public, giving the Indonesian and also whole the world recording from hearing process. We live stream the entire trial process via YouTube Jakarta Nikus. It's our college mine. So we from the beginning and until the last process in hearing, we found the several duties include the first, I think, Fatia and Haris were separate into different trial case number. Lawyers had protested strongly in the process, but they were still separated. However, during the examination of the witnesses Luhut, the and also the next year, the entire examination was made into one trial. So the judge actually using one trial processes in the hearing process. So indictment made by prosecutor was legally flawed because there was a mediation process in the police investigation should have been carried out unilaterally by law enforcement at request. Also, as well as accusation, the word of criminal, Luhut as criminal, that were not reported by Luhut. In criminal defamation, there was be a complaint. So the judge, the prosecutor cannot charge Luhut, Fatia and Haris without report by Luhut with in the term word of criminal. So the judge also ignore in the exception process, interlocutory rescission, the judge ignored the SLAP exception from the lawyer, which according to Supreme Court regulation must be decided in an interlocutory decision. So the judge trying it's in the end process, in the end decision. So another audit is during the Luhut examination as a witnesses, civilians, diplomatic mission, the media, journalists were not allowed to enter the trial. Even me as a lawyer and our college obstructed and prevent from entering. So we are debating the police, debating the court of officials. So the court was full of provoking Luhut supporter in the room. So when we are coming, we are going into the room of court, there are full of Luhut of supporter. It was also full of police and army. Can you imagine? Army of officer. And at that time, the whole cases, maybe 100 more than cases, it's stopped by the court. So only one case in that day, process in the court only for protecting Luhut as a government official. So also another audit, prosecutor tried to divert the examination by alleging Haris Azhar motive were due a grudge over a share request in Papua. So something that was not in the indictment and was never proven in the trial. So it's like shaming and also character assassination. And at the same time, not only in the trial, at the same time in social media, in X, and also in Facebook and other social media, a lot of buzzing. What the motive from Haris Azhar? It's same sound, same the word with in the trial process. So the Luhut and the team is very preparing for character assassinating for Haris Azhar, and also prosecutors often make things up, sitting the pros and pro and contras of YouTube comments as evidence of writing. Can you imagine comments from YouTube as a writing? So the prosecutor bring because there are riots. The number of article 14 and 15 from criminal code is should be riot from the disinformation or hoax. So the prosecutor use pros and cons in the comment YouTube as evidence. Also another audit is during Luhut's explanation as witness. It's I mentioned before. And also another, the prosecutor is very dominant and does not carry out his duty as a state official and function independently by distorting facts and undermining public participation in corruption prevention. So they are counterattack the public, counterattack the UN Special Rapporteur, counterattack Human Rights National Commission. So the prosecutor continued to provoke and ask a question, a very inappropriate and ensnaring manner. So with the sound and also what the moment when they are trying to leveling up the sound like that to witnesses and the experts. So usually we are condemn prosecutor, and also Haris condemn the prosecutor, and the people seeing what the prosecutor did in the hearing process. And also prosecutors ignore strong evidence from lawyer relating to SLAP, strategic lawsuit against public participation. We are bring a lot of evidence, hundreds evidence. The Fatia it's long, and also Haris a long process from 1998 Haris, for example, as a human rights defender, but the prosecutor rejecting this. Even the prosecutor counterattack the Komnas HAM, and also counterattack the 3 UN special reporters who testified that Fatia and Haris were human rights defender and environmental defenders. They are also it's very shaming for our prosecutor, yeah. The facts in the trial successfully reveal the fact that Luhut Company, Toba Sejahtera, Tobakomdel Mandiri, Tambang Raya Sejahtera had business agreement with West Mining from Australia company and also Madinah Kuruto Ain, ya, Indonesian local in Papua. But the prosecutor distort the facts and corrupt many witness and expert testimonies about this. Also, the prosecutor expert of ITA expert actually praise the role of NGOs conducting research as a good thing and consider that what Fatia and Haris were doing is the public interest, yeah. So the last but not least, the judge will deliver the verdict on 8 January 2024. So free Fatia and Haris and stop criminalization. Thank you, Nadine.
That is so true, Masis Noor. Free Fatia Haris and stop criminalization. That's a huge closing for your presentation. And thank you very much also for presenting most of the oddities happening within the hearing, which was really odd because we can hear even after the examination of several witnesses and expert witnesses, the prosecutor would not seem to process the data, would not seem to process the hearing processes. And at the end, they would just still go for with their very first indictment in the April of 3rd. So meaning that they don't have any sense of political will or any sorts of all forms of wills to acquit Fatia and Haris, which is quite endangering to our shrinking civic space. And this will be our next discussion in regards to the sub-theme of the role of Fatia and Haris, the fatal role of both human rights defenders to exercise their freedom of speech and expression, which they try to voice out what Norman stated before, the dangerous situation in Papua, the ongoing criminalization case of Fatia and Haris, as explained by Masis Noor, and how we can underline this case as, again, a form of an alarming civic space in Indonesia. So now we would like to hear more from Mas Hanung from Forum Asia. Thank you very much again for being here. We can also see that Forum Asia, in regards to the two cases I've mentioned before and elaborated by our previous speaker, have been focusing on advocacy programs for the protection of HRDs. So would love to hear more on your perspective on the previous presentations by our panelists. Mas Hanung, the floor is yours.
Thank you very much, Nadine, and then also Contrast team for conducting such a very timely briefing. Because although I know that some of us might have maybe already taken their year-end break, I'm nearing Christmas and New Year as well, but I think we are all equally concerned about what's going to happen in the 8th of January, and we are, as much as possible, will try to keep the issue afloat, and then put some lots of attentions until our demand is heard. Just basically, like my sister mentioned, is free Fatia and Haris from all charges. So allow me to introduce myself first. My name is Cornelius Hanung. I'm in East Asia and Assistant Program Manager of Forum Asia, and we are a regional network of 85 organizations across 23 countries in Asia, and focusing on the issue of human rights, fundamental freedoms, civic space, and also protection of human rights defenders. And today, allow me to give some perspective as well with regards to what happened with Fatia and Haris, and also to express Forum Asia's solidarity for both prominent human rights defenders and activists who have shown tremendous bravery and then determination, dedication in speaking up for communities in Papua. And however, it is very unfortunate that instead of receiving recognitions and their rights being protected as enshrined in the law on human rights of Indonesia, they are currently facing charges and being persecuted. And yes, I think it's very unfortunate that to see efforts to shed light on the allegation of corruptions, military operation, and business operation, and their detrimental impact on the people of Papua are being met with criminalizations. And then to see demands for transparency and public participation are being met with judicial harassment. And although the case of Fatia and Haris is quite high profile because it is brought by the one of a prominent figure in Indonesia, the coordinating Minister of Maritime and Investment, Luhut Binsar Panjaitan. I believe these represent what risk and threats await human rights defenders, activists, or even the public in general, particularly those who speak about human rights violation and are critical of the government. Like some of the campaign previously mentioning that everyone can be a victim of these as well. So Forum Asia has been consistently monitoring and documenting cases related to human rights violations against human rights defenders, and at least been based on our recent publications that around 196 cases of violations against human rights defenders in Indonesia are recorded from January 2022 until the end of 2023, which is now. And these violations include targeting CSOs, media, students, and activists. And among that, restrictive laws and judicial harassment have been used in about half of these cases, with almost 75% of them being related to the freedom of expression issues. And the criminal defamation provisions under the Electronic and Information Transaction Law, the one that's currently being used against Fatia and Haris as well, which we know is a draconian law provision as well, have also been frequently used and recorded. And then I would like to quote the data issued by the Southeast Asia Freedom of Expression Network, that at least 89 cases of judicial harassment related to problematic provision of the UU are recorded from January to October 2023. So this trend of judicial harassment tactics to target online expressions, online freedom of expressions among human rights defenders is not limited to Indonesia, unfortunately, but it's also increasingly happening as well in other Southeast Asian countries, especially since the COVID-19 pandemic happened. Various pretexts such as national security, defamations, and disturbing public unrest are being used to restrict freedom of expressions. And this is not only sending a chilling effect to freedom of expressions, but also violating the right to participate in decision-making process as supposed to be recognized in the Universal Human Rights Declaration and ASEAN Human Rights Declaration as well, in which Indonesia is a party. And returning to the case of Fatia and Haris, as Mas Isnur informed that they're also facing criminal defamation charge under the problematic ITE law, which we have been criticizing a lot as well. I mean, not only CSOs, but academics and the public as well. And on that, Mas Isnur also mentioned that just recently on December 5th, the parliament passed amendment to the law, despite oppositions, basically from civil society and critics from civil society and media. Why? Because first, the amendment fell short of civil society demand, as the problematic provision like criminal defamation are still there, still being retained, although there is some changes with regards to the sentencing. And then even more worrying, the revised law also introduced a new provision that criminalized the intentional dissemination of content containing false statement that might cause public unrest, which is punishable by imprisonment. So these poses an additional threat to democracy as it undermines the right to, of course, freedom of expressions and public participations, thereby significantly impacting the quality of democracy in the country. And several legal analysis have shown that the amendment is not in line with the international human rights laws, such as the ICCPR, particularly regarding the proportionality and necessity, and who got to decide about the fake news or false statements. The terminology such a fake statements or fake news itself have been seen as problematic by the international experts, such as the UN Special Rapporteur on Freedom of Expressions. And then also to note that Indonesia is also a state party to the ICCPR. And then the other critics against the amendment is that these have been done with a lack of transparency and access to civil society to participate. So this further, again, undermine democracy and civic space in Indonesia, because not only the use of restrictive laws being increased, but also the process of making and accessing to the lawmakers on influencing what laws needs to be amended and then adopted has been severely restricted as well. So with such systematic oppressions, what does the future hold for human rights defender, especially with the upcoming election next year? I think the question is open for all of us to reflect and to discuss. And then I think my last point is it is worth noting that Indonesia basically has been re-elected as member of the Human Rights Council for period of 2024-2026. And in its candidacy, Indonesia has promised to preserve the fundamental civil and political rights of all persons. And however, what has happened with Fatia and Haris, including the oddities discussed by Mas Isner as well, is not a good example of promoting and protecting human rights. It's rather it undermines civic space and human rights itself. And even the UN Special Rapporteur on the freedom of expression assert that reporting on human rights, government activities, and allegation of corruptions should be a type of expressions that need to be protected, not to be restricted and criminalized. And then and it's supposed to be like the ability of civil society to convey criticisms and then allegations to the governments needs to be seen as a precursor or indication of a healthy civic space, because then the role of civil society for check and balance and to increase public participations are basically functioning. But with these situations, it's really hard to say whether we have a functioning civic space in Indonesia at the moment, particularly with what will be happening with Fatia and Haris. So therefore, I think January 8th will be a significant date to observe the trajectory of human rights and civic space in Indonesia. And I will end my points with a sincere hope that the court will side with the human rights defenders, and then Fatia and Haris will be acquitted for all charges, and we can work together to review, amend restrictive laws, and really establish a healthy civic space as we envision as a civil society and as a people of Indonesia together. Thank you, Nadine.
Thank you very much, Masano. One of the core points which I received from your presentation is where you mentioned a functioning civic space, which is really relevant to what Indonesia has promised in a lot of international networks and international promises. For example, we have also Indonesia in the previous reporting of the UN Special Rapporteur for Freedom of Peaceful Assembly and of Protection and of Assembly and of Association, sorry. There, Indonesia promised to the protection of human rights defenders in the rights to their dissent. But clearly, this does not apply to both Fatia and Haris, and also to the condition happening in Papua, where there were a lot of protests coming and going on. They're voicing out about racial and also discrimination in the form of violence, extrajudicial killing, as mentioned by Norman, and etc. So yeah, let's just see how January 8th will go, as if Indonesia will exercise their functioning civic space as promised. Thank you very much, Mas Hanong. Last but not least, we have Justin. Hi, Justin.
Hi, Hi, Nadine. Thank you very much for having me.
No, I'm so happy to have you here. Yeah, we are very much aware that FIDH is one of our international colleagues who have monitored, and not only indirectly through online, but also directly to the court during the plea agenda, which occurred on the 27th of November. So we would like to ask from Justin, FIDH colleagues, how this criminalization against HRDs, specifically for Fatia and Haris, where states should have seen this transnational issue and should more contribute in protecting them instead of criminalizing them as guaranteed in international procedures. So yeah, I would also love to hear maybe if you can touch upon how Indonesia is absent in the law itself for the protection of HRDs. For Justin, you may have the floor.
Thank you very much. Good evening to you. Thank you very much for inviting me to take part in this very important discussion. And many thanks to the three other panelists and to you, Nadine, for your very insightful interventions. So I am Justine Lavard, and I work as a program officer at the Human Rights Defender Desk of FIDH, the International Federation for Human Rights. And I'm based in Paris, in France. So first, I would like to express FIDH solidarity with Fatia and Haris in the face of the judicial ordeal they have been facing for years now, and which has been extensively described previously by our colleagues. Fatia and Haris's case is particularly close to FIDH's heart, as they were both leaders of Contrast, and Contrast, which is a highly valued member organization of our network in Indonesia. In addition, since October 2022, Fatia has been elected as the vice president of FIDH, which represents a great recognition of our human rights work. Since they were first unjustly targeted by a government official back in August 2021, FIDH closely monitored the case, as you said, Nadine, and stood alongside Contrast, Lokataru, and many other organizations to raise awareness around their case, with the aim of ultimately obtaining the dismissal of their charges. Since 2021, we used a wide range of advocacy tools at our disposal at FIDH level to support Fatia and Haris. Most of the time, I must mention that we did this within the framework of the Observatory for the Protection of Human Rights Defenders, which is our partnership with the World Organization Against Torture, OMCT, within the framework of which we are addressing human rights defenders issues. So, as some examples of the mobilization we participated in, FIDH led or joined several texts of public mobilization in an effort to mobilize the international community and the public opinion as widely as possible. To this end, we issued urgent appeals, joint statements, and open letters, all with different targets in order to reach a wide range of stakeholders. And also, we disseminated these texts through our website, but also social media, and try to enhance the campaign on social media for their case to be dismissed. We also referred their case to the UN Special Rapporteur on Human Rights Defenders. The mandate officially wrote an allegation letter to the Indonesian authorities in October 2021, expressing our concern over the criminalization of the two defenders. And since then, the Special Rapporteur mandate is closely monitoring their case, and we are in close contact with them to update them so that they can follow and remind the Indonesian authorities that they are watching them and they are following the case, etc. And we also mobilized other advocacy levers that we have, like the coordination of national human rights commissions in Asia Pacific region, the French Ministry of Foreign Affairs, and key contacts at the European Union level, for example. And a last action that we did was, as you mentioned, Nadine, on November 27th, during the hearing when Fatia, Harris, and their legal team delivered the closing arguments of the trial, we carried out a judicial observation and solidarity mission in Jakarta. And so a colleague from FIDH assisted to the hearing and met with the defenders and their legal team, so that they can exchange and discuss about the strategy and the ways forward. So it was great for us to be able to assist to the trial, and it will be like it will be a really great help to continue advocate in the right way for their case. At the same time, we have been using of FIDH network to increase pressure on the Indonesian authorities. So Fatia and Harris's case have been raised in several occasions during various events, and it is followed closely at the political level by FIDH governments. And more recently, we asked all of our 188 member organizations around the world to take concrete actions. So all our member organizations have been encouraged to write letters to Indonesian embassies in their countries, to the Indonesian government or to their own government, insisting on the prominent role of Fatia and Harris and advocating for the case to be dismissed. And they have also been encouraged to organize protests or sit-in in front of Indonesian embassies, express their support online, on social media, and write public statements. So we do believe that all this kind of coordinated and increased pressure works, as it proved to work and bring significant changes for other cases in the past. So we are hopeful that this will contribute to have like some sort of a happy ending on the 8th of January, if I may say. But unfortunately, as you, I think, all already know, Fatia and Harris's case is not an isolated one. In other countries too, human rights defenders are directly and publicly targeted by officials, as it is the case, for example, in Algeria or Nicaragua, for example, just to name a few. It's just to give examples, but there are a lot of instances like that. And the authorities in many countries are increasingly using stigmatizing rhetoric to discredit defenders and their work. Often, these same authorities are suing defenders who have only done their legitimate work, and exercise their rights, as it is the case for Fatia and Harris. But instead of stigmatizing and marginalizing them, the authorities have a duty to protect human rights defenders and must respect their rights and freedom. This obligation is set out in numerous international human rights instruments, and most notably in the 1999 Declaration on Human Rights Defenders. And as we celebrate this year the 25th anniversary of this declaration, we still have a long way to go, because as we see, the protection of human rights defenders is really not effective in any part of the world, really. So, and indeed, we observe worrying trends as a human rights defenders member of our network at FIDH, but also like human rights defenders at large are criminalized and targeted in in the region, in the Asian region. For example, we are following closely cases in Bangladesh or in Kashmir of members of our network, and in the world also. Like I could like cite you like at least 70 countries maybe. So let's not go down that road. But yeah, we really see that it's widespread in the world, and that human rights defenders are targeted for the legitimate activities like all the times. And so this has huge consequences on their work and capacity of action, and thus on our rights, the rights of everybody. So this trends only shows the crucial role of human rights defenders that they are playing in our societies. And this is why we will continue to be by their side and fight for them with all the tools that we can think of. So thank you very much.
Thank you very much, Justin. And we would really hope that from what I get in your presentation is that more international communities would jump in to this case, because HRD, shrinking civic space, the civic space terminology itself is a very much basic rights that we should claim, but the case which happened to Fatia and Haris is clearly not the case here. So we would really love to have more international colleagues jumping in. And by that, let me close the discussion by entering the discussion session. So for those who would like to ask from the YouTube channel, or for those who would like to ask, I see several participants here in also the Zoom room. So if you would like to ask or maybe confirm or clarify several things to our speakers, please do. If not, let me ask. If not, let me ask our speakers. There has been none questions at the moment. Okay, so first maybe I would like to go for both Masis Noor and Norman. For Masis Noor, first I would like to ask a most frequent question asked. What is going to happen next? Because we know for sure that things are not progressing well. If this might be a good conclusion for us to have in this discussion and all of the oddities you have presented before. So what's next? If, for example, the worst case is that Fatia and Haris would not be acquitted from their suit from the public prosecutor, what will be next? That's for Mas Isnur. For Norman, and what would this mean for the violation happening in Papua? What would this articulate? What would Fatia and Haris's imprisonment mean later on for Papua's current condition at the moment? So for Mas Isnur, you may go first.
Yeah, thank you, Nadine. So, at the moment, 1 minute or maybe 5 minutes after our our pleidoy, me and our college, our lawyer college discuss. So with this prudent evidence, with the very undebatable evidence, so we convince the judge will make a free for Harris. Even the article, the article is relating with Harris and Fatia, but based on the regulation, based on our law, based on the Supreme Court regulation, so the indictment, it will be rejecting. As a environmental defender, it's has to be free to Faris and Fatia. So it's just 5 minutes. But in the fact, yeah, in Indonesia, we found when the prosecutor charged the activists and also a lot of people with the ITL law, we found 95%, yeah, its conviction rate will be imprisonment. So we worried about this situation. So the judge will not make good attention for our evidence, yeah, our argument. So we worried about this because, for example, the police, the prosecutor, they don't care about the public opinion. They don't care about pressure from the international. So they don't care about special reporter and also a lot of amicus curiae come from the international human rights institution. So we worried about the same situation with the judge for now. But yeah, for lawyer, we still having optimism. We having time until 8 January. So we waiting for the public, for the journalists, for the all of people of Indonesia and also all the world, send the letter. Send the letter to the government, send the letter to the parliament member, send the letter to general prosecutor, send the letter to Supreme Court, send the letter to the judge who handling this case. So we giving the tsunami tsunami support from all the world, from the people, from the activists. So we Raya tolongin. So sorry. So we hope with the tsunami paper, with the tsunami amicus curiae from the whole the world, convincing the judge to giving the best, to giving the verdict as as a neutral position, without the interference, without the pressure from the Luhut. So maybe 1 month ago, yeah, the head of the court, it's now as a judge in the appeal process. So it's having a promote. So we been thinking about this situation when in the last process, the head of the court have a promote career to appeal court, and also the vice head, yeah, to be as head of court now. So we worried about this, and also we worried about the situation, same situation. The Sandi, one of the prosecutor, yeah, is also the prosecutor, same prosecutor with the ice cold Jessica case. So when the hearing process, Netflix published the film about the ice cold, and the Indonesian Netflix followers and also the netizen mentioned a lot about Sandi, same attitude with in the ice cold process and in the Haris and Fatia process. So usually we worried the police and also the prosecutor, they did like communication before. So it's something as common issues. So it's yeah, they work in the back of wall, yeah, the word they communicate in the behind the table. So we worried about this, but we have to optimize until 8 January. Even usually in the secondly, usually the judge verdict, yes, usually, yeah, in the other case, in our experience, maybe in Jumhur and another case, yeah, in the same situation, usually the judge giving the verdict Fatia and Haris wrong, and they giving like apa ya, masa percobaan tuh apa ya, Hanung ya, apa ya, probation time. Yeah, probation time. So usually the judge will not imprisonment the activists. So yes, they are wrong with they fulfilling the article and giving verdict they wrong, but without imprisonment. So this like apa ya, soliloquy ya, apa ya, situation for us. Yeah, even we are appeal or no, but I assume yeah, Fatia and Haris will appeal if the court giving verdict as a wrong position. Thank you, Nadine.
Thank you very much, Mas Isnur. Moving on to Norman, please.
Yeah, thank you for the question, Nadine. I mean, the case against Fatia and Haris is intended as an intimidation. Several actors have tried to disentangle the complexities behind the Papua conflict, and it has often resulted in one or the other form of intimidation or obstruction of work. There are human rights defenders in Papua who experience that regularly. It is very difficult to work as a human rights lawyer in West Papua. It is very difficult to work as an independent journalist in West Papua, in the Papuan provinces. And their situation would be even more under threat because the message is very clear: don't touch this stuff. You can talk a little bit about some issues, but not the entanglement of military, economy, and politics, which in the case of Papua is even stronger than or a very emblematic example of this entanglement. And this entanglement is really what has been holding Indonesia back for so many years on these efforts to promote human rights and promote a rule of law-based, open, pluralistic society, something so many people in Indonesia are waiting for and are putting their efforts into. So all this would be pushed back, and the limits that are set on actors in Papua to do something about it are much higher than the ones in Jakarta. It is much easier to kill an activist and cover up their work. And that's why it is so important that so many Indonesian organizations stood up together with this research that was then referred to by Fatia and Haris. In West Papua, you cannot just go by car to a mining site. The military will stop you. Why does the military control the area around mining sites? You cannot report about it. You can, as a foreign journalist, you cannot enter West Papua. By now, even the schooling and some of the healthcare services are provided by untrained military personnel. Untrained in the sense of they are not trained to provide education. They don't know how to teach children, but they're standing in front of the children or soldiers sitting in the church or other places of worship with a gun, monitoring, intimidating. So this climate of fear that causes a lot of resentment and resistance, this climate of fear is further increased. So this is aggravating the conflict instead of disentangling it. I think for the majority of politicians, this is not in the interest of the future of Indonesia. The interest is to resolve this conflict, make all illegal entanglements open, transparent, and promote a rule of law-based approach in Indonesia. So this is would be a very serious setback. I would argue maybe one of the most serious setbacks since the killing of Munir. When human rights defenders, very prominent, obvious human rights defenders with a very clear record for decades of promoting rights and rule of law are intimidated for valid research, for raising concerns for what they have done, for using media to engage civil society, then this would be a very black day for the history of human rights in Indonesia. And I expect Indonesia would face a serious international outcry. I think many actors have holding themselves back to wait for this court case to proceed. But I think Indonesia cannot afford such high-profile political prisoners as Fatia and Haris would be. I think they would be icons of, would become icons of the struggle of civil society in Asia and globally. I don't think this is what the prosecutor really was clear about when he started this attack against civil society. Thank you, Nadine. And if I may, I would like to ask a question to Mas Isnur. You explained that the case against Fatia and Haris was split up into two. What is the advantage from the perspective of the judges or the prosecutors in this? And my second question is, if this case would go to an appeal at the Supreme Court, do you think the Supreme Court will be even harder to deal with than this or easier? Thank you.
Mas Isnur, you may.
So, langsung aja Din ya. Ya, because Luhut having a power structure at now, so we don't know about the future because Indonesia now on election process. So Luhut and his position in October 2024. So when we continue process to appeal process, this need time, that time. So maybe 6 months until 1 year. So we don't know about the situation after Luhut falling down the situation, falling down the position after Jokowi's era. So one of main debate on election process, it's relating to freedom of expression. So in the first debate, the official debate by election committee last week here. So the issue of freedom of expression is one of main debates. So it's also helping us to bringing the same the same argument, the same situation to the appeal court. So when Luhut trying to intervene the judge in the first process, yes, maybe they have a process, but when the process is appealing and going to the cassation process in the Supreme Court, Luhut have to using his power again. So we don't know how long he can go with his power to intervene the court here. A lot of cases the LBH win in the appel case. So for example, we having a cases from singer in Cipulir for children in the Selatan court process. The verdict is yes, imprisonment for 8 years imprisonment. But when we are appeal, the appeal process giving free for the singer, for a children's singer. A lot of cases we are winning in the appeal and also in the case process. But in another case, for example, for 2 lawyers and 21 labor charged with the attacking, fighting with the police in 2015. In central of Jakarta court giving a free or no, a verdict. So we don't know this in Indonesian court. We like a magic, like a magic. We don't know about the result until we hear in the last of process. So it's so like I mentioned, situation is the soliloquy, the confused situation in our law. Thank you, Norman.
I think there was one more question. The first question asked by Norman Mas Isnur regarding if there has been 2 separate cases between Fatia and Haris, what are the advantage and the disadvantage of that?
So it's usually it's like a trap for a suspect, because when the prosecutor not good or not having prudential witnesses, they use one suspect as a witness for another. So in this case also, the prosecutor trying this trap, same situation. Can you imagine? Usually in all the cases in Indonesia in criminal processes, usually after the witness and expert from the prosecutor, it's next is witness and expert explanation hearing. So in this case, after witness and expert from the prosecutor, the judge giving the decision. After that, so Haris and Fatia explanation. So it's very rare, very rare situation. So we are rejecting Fatia and Haris as a witness each other. So it's very rare. So after we are rejecting the process, so the judge receiving our rejecting, but the judge giving time next week, Fatia and Haris as a suspect in the court process is very rare. So after Fatia and Haris giving explanation, the witness and expert from us, from the lawyer. So it's the trap for us, yeah. So when in Luhut, so we are giving attention. We are giving like a warning for the judge. Judge, if you are separate the case, you have to ask the question for the some person. For example, Luhut, yeah, twice moment for the Haris case and Fatia case. So when the Luhut time, the judge, yes, it's confusing for us. We cannot get the information for same information, same question for twice. So it's the situation. So yeah, what the beneficiary for us? None. But for the prosecutor, yes, it is a trap. Usually we the name is saksi mahkota, crown victim, crown witnesses. So it's we explain to the judge, to the prosecutor, it's prohibit in ICCPR, but they don't understand about ICCPR. Thank you.
Thank you very much, Mrs. Noor. And Norman, did that satisfy your answer?
Thank you. Yeah.
Questions? Okay, thank you very much. Maybe we would have the remaining time for maybe last question to both Justin and Mas Hanum. In regards to the international monitoring for both Fatia and Haris, maybe more or less the same question which I asked to both Mas Isnur and also Norman, regarding what will be the next step for us international colleagues to have this international solidarity happen for both Fatih and Haris while waiting on 8th of January, and if they should be continued to be not acquitted, what will happen next? What should be done by both FIDH and Forum Asia as two of the international organizations? Maybe I can start with Justin first, and we can head to Mas Anu.
Yes, thank you. So as I mentioned earlier, for now, for the upcoming days and weeks, we are trying to increase pressure as much as we can to let the Indonesian authorities that we are watching them and we are monitoring the case. And so if we will of course react after the verdict as the FIDH and together with our colleagues of OMCT, and I guess I don't want to like overstep because the strategy we will adopt after that will really be in coordination with Contrast and with the legal team of Fatia and Haris, and what like we always do, like we coordinate with the organizations that are following the case in the country, or and the lawyers. But yeah, we will be able, if it's relevant and if it's useful, to mobilize further and to try to use different and additional tools, and to reach out to our network if necessary, and to reach out to international stakeholders, even if I understand that maybe this is not the most efficient thing to do. But yeah, we have plenty of options, but I won't like announce a strategy right now, because it will be done in cooperation with all organizations involved around this case. But we will continue surely to monitor and follow very closely, and to act in solidarity. That's for sure.
Thank you very much, Justin. Next, Mas Hanung, please.
I'll be very practical, and then also seconding what Justin has mentioned, that we will work together closely with the legal team as well, and then with the members of Forum Asia and Indonesia as well on that. Because as a regional and international organization, I think what we don't want to do is to work in silos and then create a bad impact to the case as well. So in case there is a necessity, and then I think there is, to keep the discussion like this afloat, and then to keep our campaigning ahead of the 8th of January, to show to the court that we as a civil society, but maybe not only civil society, but also public in general, that we are watching the cases, we are expecting for the best outcome to happen. Then this might be also creating a pressures, because as I think previously Mr. mentioned, the international human rights law might not work, or they don't really care about ICCPR, but I still believe that they do still care about the opinion of the public, of people. So it's also questions of from us as well, how we can actually ask like the wider audience to engage with this process until the 8th of January, or maybe even after 8th of January, if in different scenarios. In a way, I see it as a work of marathon, that this not will only like end on the 8th of January, because like I mentioned, what we happened on the court that time will setting the course of how the Indonesian civic space will look like. And then let's hope that amidst many issues like elections, crisis happening in different parts of the world as well, we also need to still pay much attention to what happened with Fatia and Haris, because then, like I said, everybody can be a victim. If they're become the victim, then everybody will be able to be the victim and in the same situation as well.
Thank you. Thank you very much to all of the panelists. And with this, maybe we can close today's discussion by maybe me giving several conclusions. First of all, maybe this has also been cut in the first part of the live stream, but just copy and pasting it here, that we have been engaging with more than 100 plus international organizations for the support of both of our human rights defenders, and we would like to hear more of this unfair trial, judging by their own perspectives, which was not supposed to even happen to Fatia and Haris in the first place. Since the increasing number of the Papuan conflict through extrajudicial killing, torture, and over-deployed military are real, and they are still happening up until this moment. And it has been one of the global concerns that when it comes to human rights fulfillment in Indonesia, we can also be neglectful to what is happening in Papua. And Fatia and Haris did not forget about this issue. So what Fatia and Haris is trying is to expose should not be responded to subpoena and unfair trial processes, but rather more positive outcomes rather than that. Because this is not only about, again, Fatia and Haris, but this is a matter of how this criminalization will form a domino effect of an endless climate of fear and silencing to civilians, to Papuans, and also to those who are concerned in the issue itself. So again, thank you very much for all panelists, participants, Pray Fatia and Haris, and stop criminalization. With this, I close this discussion, and let's view and monitor together on the verdict on 8th of January, 2024. Thank you very much, and have a pleasant evening ahead.
Thank you, everyone.
Thank
Thank
you
you very
very
much,
Fatia
Nadine,
and
as well,
Haris.
for moderating.
Thank you.
Thank you.